There you are. You're up, Mr. Upson.
May it please the court, Keith Upson for appellant Michael D. Pasquale. No one looks concerned. I trust everyone can hear me. All right. Okay. Thank you. I'm used to doing that status check just to make sure. I'd hate to finish and find out it was all. I'd like to reserve 2 minutes for rebuttal, if I may.
Sure thing.
Good morning. It's genuinely nice to see all of you. I would prefer it in person. In fact, Judge Northcutt, as a quick aside, you and I had the last live oral, I believe it was first week of March. I think the week after that, everything was shut down.
Were you on that panel? I mean, I remember being on that panel.
If I remember correctly, then it was with anxiety, even at that point, that we were meeting in person. But this is my first argument since, and it's good to see you all.
I probably should have said this early, but when you see us looking back and forth, we're looking at the record on other screens. We are not ignoring you. So
no, I
should have said that early on, but that's probably
our setups are, it's like we're in a radio studio or something. And
I feel like Captain Kirk. I've never had 3 monitors.
Well, and I understand that, Judge, and even on the bench in person, I've never taken. When a member of the panel looks at the iPad or other screen, I've always understood that that's what the court was doing. And
when I look at another screen, I always snore. So don't take it the wrong way. It's good to see you, Mr. Upson.
Thank you, Judge.
And you, Miss Okindo.
I'm sorry, Judge.
And you, Miss Okindo. Yeah, I'm going to start the clock now.
Okay. Well, and I'm sure that fourth case doesn't, and the bench doesn't appreciate it either, because by now we're all starting to get pretty hungry. But fortunately, this is not a complex appeal. In one sentence, 90% of someone's net income for alimony is excessive. And I thought, Judge Northcutt, you were about to go ahead and stop me there. Okay. Well, and your silence this morning made me wonder if you were going to dominate the questions throughout this argument. But
well, I mean, I think what happened was pretty clear. The judge felt this fellow's needs were being taken care of, his expenses, all except for, I think, what, the power bill.
It's a very small amount, whatever the difference.
Very small amount, and the question is if you want to strictly apply the statute that says, net income of the payee can't be more than the net income of the payor, except when the judge finds exceptional circumstances. The question is that an exceptional circumstance? And are kind of on its face, and I'm describing fact findings by the judge, even though the judge didn't say the words exceptional circumstance. Doesn't that qualify?
Well, and I think that's really the threshold issue as we briefed it, and as was pointed out, and I'm sure will be again in the answer brief. Do those findings, and I have struggled not to use words like free ride, and I think, Judge Northcutt, you were trying to find a more artful way to say, but that's essentially what this came down to. Our position is initially that if the trial court was going to leave the payer with significantly less net income, you've got to expressly enumerate the basis for doing that. But
didn't this judgment do that? I mean, I have described any fact to you that came out of the record as opposed to the judgment, right? The judgment
that's
set all that up. The judge made those findings. No one has contended that they weren't supported, that they were inaccurate.
But it's our position that there is no authority that would support a finding of 90%.
Well, except the authority that says when you have contribution to someone's, expenses by, a partner, a wife, a grandmother or whatever, that you factor that into their need or ability.
You do. In fact, you
And so
actually,
here's
Judge.
a fellow whose need is, I think the power bill was like $180 a month. Is that what it was? I mean, I would take that power bill in a heartbeat, but, and so his income, as diminished as it was compared to previously, outweighed that very minimal living expense. Did it
Yeah.
not?
Judge, I think the cases support a lesser position that we can consider those contributions for the purposes of calculating net income. I think there's another step that has to be taken before determining
Well,
outright.
it's not a question of net income so much as it is need and ability to pay, which is the
Well, but that's what I'm contending, Judge, that you have to first determine.
Ability to pay, would be income or income ability, less what you need to live, less what your taxes have to pay and so forth. And
not to nitpick, but it's my position that net income is a calculation that has to be made on the way toward determining net income. And what we have
net income is important if you're going to say, you got to have exceptional circumstances to give the payee more net income than the payor. Otherwise, there's no requirement in that statute that you calculate net income, is there? I mean, the judge needs to make findings to support an alimony award or failure to award, but we're not in an original initial judgment. We're on a modification.
Modification. And I think what the judge's other findings, and I'll get to those in just a second to the extent I can, but even in a world where I agree that you can take those factors, and the trial court should have taken those factors of what his expenses were in calculating net income and calculating his ability to pay, we still don't have a single case that says 90% is okay. Having a roommate pay some of your expenses certainly factors into it.
You don't know what all those PCAs are out there.
Well, but if that's a can of worms, Judge, that if we were required on direct appeal to open up, and of course we can't, but Melton didn't say it's okay to take 90%. McCall didn't. Judge, you relied on McCall in authoring Morrell. Morrell only held that a living companion's contributions to those expenses may be considered when assessing financial circumstances. And
well, it's pretty clear that the judge in this case did consider them.
Did consider them.
And
but
it is permissible.
But if you go back to what I was saying, Judge, or if you would permit me to go back to what I was saying about that net income, you were muted there, I think, Judge.
I said I would permit you to do whatever you want, Ms. Robson.
Thank you, Judge. Specifically dealing with Melton, I believe that was the postal worker case. What Melton was doing was reporting a net income that was reduced by amounts he was paying into voluntary contributions to bonds, including at least one charity bond. So I think we all understand the purpose and intent isn't accomplished if you let somebody give away your income. If you give half your income to the Cat Alliance, I mean, certainly a worthy cause, but for the purposes of calculating your ability to pay spousal support, you're going to have to make those donations below the line, and above the line, we're going to figure out how much you have to pay in alimony. But the real controlling and I think dispositive concept here, Judge, is that we're talking about ability to pay and net income, but that's only one side of that. There's two components to that equation. Vega at 883 points out, you've got to set an award the payer has the ability to pay, and it has to be as fair as possible to both. But going all the way back sort of to the mothership, Canarchus, which I'm probably always mispronounce, which this court cited in Melton.
This court cited in every case it's ever written in family law.
Well, it's more equitable. that the court has to be careful neither spouse passes from prosperity to misfortune or misfortune to prosperity. And while it's absurd to characterize Mr. DePasquale's situation at the time as couch surfing or living off the graciousness of others, in effect, that's what was, so he reduced all of it. But hypothetically, if he lived in a cardboard box on the beach and was fulfilling his dream, I mean, are there any facts under which it would be acceptable to take 90% of his entire income?
Well,
And
the
our
question
position
is
is that,
whether it's within the judge's discretion in this case.
well,
That's the issue we have. And let me ask you this, Ms. Rupson, although the judge didn't go anywhere with this other than observing it in his judgment, but there's a pretty substantial chunk of the proceeds of the sale of his business that were never accounted for. How do we factor that in? And how do you think the judge did?
Judge, let me answer that with an answer that's not to the question that you asked.
Well, you wouldn't be the first.
Because I really want to focus on what the court expressly found. And this is at pages 212 and 213 of the record. Under this motion to modify, the court found a substantial change in circumstances that wasn't contemplated at the time of the final judgment, that it was sufficient, material, permanent, and involuntary, and that Mr. DePasquale had diligently searched for employment during his period of unemployment. And the
That
reason
can all be true, and he still have, what was it, $300,000 stashed away somewhere? I mean, the judge didn't say anything beyond the fact that it was unaccounted for, but
no findings as to waste, and without an express finding as to waste, I appreciate.
well, no, not necessarily. It could go to his ability to pay, could it not?
It can be
And even if
considered.
it's not wasted.
It can be considered, but the court didn't make those findings. And
I'm not sure the statute requires those express findings at this post-dissolution stage. Plus, the case law is replete with findings that if we, as a panel, can read the record and discern from the record there is evidence to support the ruling, we can affirm, correct? I mean, there's testimony he's remarried and she's paying the majority of all of his expenses for a long time prior to the hearing. So he's not destitute. So, and that's not just a live-in girlfriend. It's not a concubine or a paramour. He's married.
That's
So
correct, Judge.
that's a
but
consideration. It's clear in the record. We know what she's paying and she conceded to it and we can read it. I don't
But
know
if-
if the judge has to specifically say that at this point, does he?
Well, your question is about abuse of discretion and whether or not there appears in the record a basis from which the court could have concluded it, which I would refer back to our initial brief and the position we took and the reason we took it, that this is not an abuse of discretion, that the threshold issue here is the misapplication of the law. Whereas here, the court made those necessary findings to grant the motion for modification, substantial change in circumstances, not contemplated, so forth and so on, that to then turn around and snatch 90% of his net income without giving us, this is why I'm doing this expressly to comply with the statute, constitutes misapplication of the law. But additionally, it was an abuse of the court's discretion. Of course, the court, Judge, you're right. If you look at it and you can see sufficient evidence from which the judge could have reached that conclusion. But, and I believe the way you phrased it, Judge, was, aren't there cases? And if I misheard that, because yes, Judge, you're absolutely right. I don't know that those cases are cited in these briefs. And the only reason I mention that is because there are also cases not cited in these briefs that discuss the fact you can't take the spouse's income and impute it to the payor. Judge Northcutt, were you? Oh,
I'm looking through the final judgment, reminding myself what I had. But that's not what happened here. The judge didn't say, well, the spouse has income of, X, whatever it was, I think 120 a year, 120,000 a year, if I recall correctly, and didn't say, therefore, I impute to him her income. No, what he said is I'm looking at the expenses that he has, and she's picking up all of them except the $180. And the case law says you can factor that in.
Can consider.
Because here's the thing: if she was making $500,000 a year, the judge didn't say he has income imputed to him of the $500,000. The judge says whatever his expenses are, she's paying all of them except the power bill. That is precisely what the case law says can be considered.
Not to 90%, Judge. There's not one.
Well, the case law, the case law doesn't say there's a hard number.
No, what it does is it gives us examples.
Yeah.
And 60% is too much. That's cited in the brief. 70%, 80%.
Yeah.
It's sort of like how long is too long on.
But keep in mind, this lady, and she was earning income, and Ms. Window has pointed out that there was income imputed to her, even though she wasn't earning any at the time of the final judgment. And so then she received a $2,500 a month alimony award on top of what was imputed to her. And I think, if I recall correctly, the net of that was between $1,700 and $1,800 a month. And now, by virtue of this judgment, she has had her alimony reduced by $400 a month. That's a pretty heavy hit on her side too, is it not? I reckon
it is, Judge, and why I think
there's no mention of a spouse or anyone else paying her bills.
Why I think it's so critical that in Vega, in Canarcas, there are still some equitable, there's some parity that the courts.
And of course, I've always said Canacris, but I remember when it first came out. I was around when it first came out. A lot of people said Canacaris, but I've always said Canacris, whatever. In any event, Canacris also underscored the importance of deference to the discretion of the trial judge. And it set the rule. You can reverse only if no reasonable judge would agree with what the trial judge did. And what you're saying is that, I don't know, you're saying it violates a statute versus no reasonable judge would have done what the judge did here?
I'm saying no reasonable judge would find 90% of his net income anything other than an abuse of discretion. And I'm further saying that the trial court's order failed to comply with the requirements of subsection 9. It's such an extraordinary outcome. I would expect it to be highlighted with flashing lights, and it's just
subsection 9 being find exceptional circumstances.
And expressly spell those out for us. Listen, I know 90%.
Well, the question is like, if say we remanded it and said, okay, spell it out, and the judge entered the exact same judgment, but at the end says, under these exceptional circumstances, where the payor has someone paying all but $180 of his monthly expenses, I find that he has the ability to pay this much. Wouldn't we be right where we are now?
That's actually the exact relief that we're asking the court
We'll see you next year.
For the two reasons, though, both the misapplication of the law and failing to comply with the statutory requirement, and for abusing the court's discretion. Remand it, and let's have a reasonable amount. And if it comes out the same way, I'll see what arguments come up.
Well, let me ask you this, and I'm not sure it's been raised, but did someone say to the judge, you can't do that without finding exceptional circumstances under the statute?
And of course, the record will either support or refute this. At hearing, I don't recall, but a timely motion for rehearing or reconsideration was filed.
And did it say that?
I think it said it in stronger terms. Okay. I think it was written with the outrage of a trial attorney who had just walked out and wondered what in the world just happened. I think it was apparent. And again, if that didn't somehow make it in the record, then I'm remiss. But I believe a timely motion for rehearing was filed, that any reader of that motion would understand exactly where that trial attorney stood on those points.
You're down to your 2 minutes, Mr. Upson.
Well, thank you.
Mr. Quinto? You are muted. You need to unmute. I do that all the time. I think I did that with Mr. Upson a minute ago.
Yeah. Good morning, Your Honors. My name is Sarah Martin Okendo, and I represent the appellee, the former wife, Donna DePasquale, in this matter. I'm going to continue to refer to them as the former husband and former wife. I think it's a little bit easier that way. To address the judge's last point, yes, there was a motion for rehearing that was filed that was cited. Pretty much what was cited in the first, the initial brief was the excessiveness of the order that was denied by Judge Hawthorne. To discuss the ability to pay, former husband has really focused on ability to pay and the excessiveness of the amount. But ability to pay is not just what your net income is. The court is required to look at more than just net income. The court should look at the husband's ability to pay, including expenses as paid for by the former wife. The court should look at the capital assets. The court should look at his income as well. And I think the court did do that. The court didn't just focus on what the net income was. The court made findings that there were capital assets. The court discussed the home that was purchased for approximately $325,000. The court discussed that there was a business that was sold for approximately $1.1 million. There were 2 new businesses purchased for $400,000. And the court did make findings that there were proceeds that were unaccounted for, as the judges discussed. The former husband did testify that he spent some of it on taxes, but that doesn't lead to the approximately $300,000 and some that was left over. So I believe the court did find that the husband had capital assets that could also be looked at in determining his income. The former husband argued that the phrase exceptional circumstances is not found in the final judgment. That was discussed heavily today. I have found, and no case law was cited by the former husband, that the phrase exceptional circumstances is required to be in the order. I believe the order is very specific on the findings that it made, and any reasonable person could read that as exceptional circumstances. The exceptional circumstances that are previously discussed, and which I think are clearly exceptional circumstances. The first being the former husband's current wife paying all of his expenses. The testimony was clear. The former husband only paid about $180, which was the electric bill, in the expenses, and the former wife had been carrying, the current wife had been carrying the remainder of the expenses since about October of 2018. The former husband was unemployed between October 2018 and March 2019. Even after that time, the former wife continued to pay the majority of the expenses. Other exceptional circumstances would be that the husband sold his business for $1.1 million, and all the proceeds were not accounted for. He purchased a marital residence for $352,000, which was unencumbered at the time of trial. There were 2 new businesses for $400,000. And as I said, the remaining funds from the sale of the business were left unaccounted for. So we believe that the exceptional circumstance, even though not phrased as exceptional circumstances, is clear from the final judgment and the findings that the judge made. And I don't believe that exceptional circumstances is required to be listed as a phrase in the final judgment. The issue regarding the former husband's current wife's income, the court is correct. The judge did not make findings that the current wife, the former husband's was being imputed at the amount of the current wife's income. Instead, the court found, as per McCall, Melton, Morrell, that the former husband's income and that the former husband's income should be should be looked at from all aspects, including any portion of his income or his expenses that are being paid by a current companion or live-in spouse, and that was what was found here. The next issue that was touched on in the brief and quickly in the argument was in regards to the former wife's income. The former wife did not testify at trial. The only evidence of her income was found in the financial affidavit, as well as the former husband did not plead a substantial change in circumstances for the former wife. The alimony worksheet attached to the supplemental final judgment really was just a demonstrative exhibit to show the former husband's ability to pay. It did not go into the former wife's need because the court specifically stated that the former wife's need was $2,500 per month as established in the final judgment. In the final judgment, in the language in the MSA and the child support guidelines attached to the final judgment were clear that the former wife would be prospectively getting an income, and her income was imputed to $1,733 per month. And based on that, the former wife's current income per the financial affidavit, plus what the former husband's been ordered to pay in alimony, do not meet her needs. Her needs were established at about $2,500 by the judge, plus her net income. Her expenses were $3,700 per month. So the alimony award is not covering her need. And if we look at Canacris, however we're going to pronounce it, one spouse is not supposed to go from misfortune to prosperity or prosperity to misfortune. Here, the former husband continues to have his needs being met by the current wife. His expenses are minimal. The former wife, however, her needs are being impacted as the current order is not meeting her needs. So if anyone is passing from misfortune to prosperity, I would argue that would be the former wife.
You didn't mean to say it that way. From prosperity to misfortune is what
Yes, thank you. Sorry, yes, I apologize. I think the main point is that we can't just look at net income. That is, the ability to pay is a broader concept than just net income. The court is required to look at all aspects of the former husband's expenses, his capital assets, his net worth, his past earnings. And I believe that Judge Hawthorne did do that in this order. At this point, I believe that we're requesting that the final judgment be affirmed. And if there are no further questions, then I would tender my remaining time.
Thank you, Mr. Kingdom.
Thank you.
Okay, you're up, Mr. Upson, for 2 minutes.
Thank you, Judge. Cash flow, and I hope you let me finish the thought, because I'll get back to where I think you're going to go.
I'll try.
Cash flow isn't income, nor is cash flow capital assets, nor is it ability to pay. So $1 million business, the testimony was money came in, money went out into failing businesses. Again, I think it's critical that this court made no express findings of waste. So I think this record supports perhaps horrifically bad business decisions, but I think the record supports that both parties are equally as eager for Mr. DePasquale to enjoy the same level of financial success that he enjoyed at the time of the dissolution. I think we're all on the same page with that. And that's why I think it's critical the court expressly found during his period of unemployment that he wasn't taking advantage of his situation with his current wife with respect to some scheme to get out of having to pay alimony. But of course, correctly, the court can consider all that money that was moving, and the court can consider the capital asset, the house. But let me ask this rhetorically, of course, because I don't get to ask anyone involved right now an actual question. Which of those things did the court rely on in determining it was a good idea to take 90% of his income? Was it the proceeds from the sale of the business? Was it the fact that the word $1 million got thrown around? Was it the unaccounted for portion? Was it that he bought a home? I can't tell. And that's why, if you're going to do it, you better make it easy for a reader who picks it up to understand which of those dollars you're dinging him for.
Or all of them.
Well, then I would want to know.
Totality of the circumstances is something that we, use. That's a phrase we use a lot.
Then I would want an order that says that, because this court would benefit greatly from not having to try and figure it out.
No.
And that's what I think 63, that's what I think the statute requires, that level of specificity.
There are your 2 minutes.
I'm sorry, Judge?
There's your 2 minutes. Your time's up.
Well, yeah, I'm asking, you know what I'm asking for, and
I know what you're asking for.
thank you all, and I hope you have a lovely rest of your day.
I can tell you that, like, for years, I could and probably still can recite the citation of Canacris versus Canacris from memory. It's 382 Southern 2nd 1197. The equitable distribution part, or the deference to the judge's discretion is at page 1200, and that was in Florida, 1980. I mean, it was just an automatic. So anyway, thank you both.